Afternoon, everyone, and welcome to this session of oral arguments at the Iowa Court of Appeals. I am Judge Mary Kenkel, and today I am here along with my colleagues, Judge Buller and Judge Langholz. This afternoon, we'll be hearing three cases. Our first case is case number 242026, Richard J. Erwin Appellant versus Michael G. Erwin and Erwin Farms 2 LLC Appellees. The appellant is represented by attorney Elizabeth Meyer. The appellees are represented by attorney Benjamin Kenkel. Counsel, are you ready to proceed? Yep. All right, whenever you're ready.
Good afternoon. May it please the court, opposing counsel. My name is Elizabeth Meyer, and I represent the appellant and plaintiff in the underlying lawsuit, Richard J. Erwin, who frequently goes by RJ, so you'll hear me refer to him as RJ today. This case involves a number of issues, and it's unlikely that time will allow discussion of all of them today. Both parties have submitted extensive briefing, and so to the extent we don't discuss an issue today, I do rely on our briefs. As it is likely clear to the court, management of Erwin Farms 2 LLC has been the subject of disputes between RJ and his father, Michael G. Erwin, for nearly 10 years. This is the second time that a case involving Erwin Farms 2 comes before the Iowa Court of Appeals. My client's goal throughout this period has actually been fairly simple, and that is to have Erwin Farms 2 operated in compliance with applicable law and the LLC's operating agreement. I want to start by addressing the only award of damages that actually occurred in connection with the underlying lawsuit, and that is the award of approximately $17,000 in attorney fees to the defendant. Even if this court rejects all of RJ's other arguments on liability in this matter, the district court still erred in awarding attorney fees to Michael G. Erwin, and that is because they were not raised in any pleadings prior to trial. In general, attorney fees are considered special damages under Iowa law that must be pleaded. And Nelson v. Pfeiffer is probably the leading case on that point. Pleading provides the opposite party fair notice and an opportunity to defend the claim for attorney fees.
What opportunity you were denied?
So I think the opportunity was to actually defend against that and make relevant choices relating to the litigation based upon a claim for attorney fees. I think that's important in the parties making litigation judgment, how they work up a case, for example.
Tract provided for it, right?
And I will challenge the court a bit on that. So I don't think that an operating agreement is actually the same as a written contract under Iowa law. It's a governing document that governs an LLC, similar to how bylaws would govern a corporation under Iowa law. So a plaintiff does not bring a claim under the operating agreement. It's not a claim for breach of the operating agreement. It's a breach of fiduciary duty. And those claims are statutory in nature. So my client's claims were brought pursuant to, Code 489, both direct and derivative claims. That would provide an opportunity to plead attorney fees for the plaintiff. Similarly, it would provide the defendant an opportunity to plead attorney fees. That didn't happen here. So if the court, embraces, I suppose, the defendant's position, it's really no different than abandoning Iowa law on employment claims, for example. Simply because a statute provides you to plead your attorney fees doesn't mean it's automatic. We could similarly say, well, every time there's a defendant in an action against a statutory claim, they should know there's a claim for attorney fees. That's not how it works under Iowa law. So we were deprived of the opportunity for notice of a claim of attorney fees. I also want to note that it's apparent the parties knew how to do this. I think the underlying court record in the prior appellate case will show that both parties pleaded attorney fees in that case. So this wasn't a new concept for the parties. I don't believe the statute cited by defendant supports their claim, and I think I've touched on that, but 625.22 applies to claims on written contract. Again, it is RJ's position. This was not a claim on written contract. These were claims for breach of fiduciary duty under code.
Suggest that the pleading requirement requires they be pled before trial rather than after?
I think that's actually established in Nelson v. Pfeiffer. In that case, I believe the court addressed that it actually has to be something raised by trial or perhaps tried by consent at trial. This was not raised prior to trial or at trial. The first time that a claim for attorney fees was raised by the defendant in this matter was in post-trial briefing. Those were briefs that were filed concurrently. No responsive briefing was contemplated. And RJ did raise that immediately upon the court's award in a motion to amend or enlarge, which was denied by the district court.
With what opportunity you think you were denied? Did you want a hearing about the reasonableness of the fees?
No, I think we were able to argue about the reasonableness of the fees, but
Exactly my point. So if you were able to argue about it, where's the harm?
I think the harm is not knowing there was a claim for attorney fees pending against my client. I suppose in any case, you could say if a plaintiff is faced with a claim for attorney fees by the defendant, you could dismiss if you didn't feel that it was worth the risk. And that might happen in any case where you're dealing with statutory attorney fees as well. So we didn't have the opportunity to make decisions about the litigation based upon an opposing party's claim for attorney fees. I will move next to the issue of the erroneous capital accounting in this matter because I think there may be some confusion generated by the Appellees' brief on this point. RJ's claim relating to this capital accounting is not one for damages. It actually relates to the propriety of the capital accounting itself. It's RJ's position that Mike has breached his duties in preparing the capital accounting, which is unfairly favorable to Mike and Janet Erwin and is inconsistent with judicially established facts from the prior lawsuit. The evidence at trial showed that Mike intends to utilize the capital accounting to distribute funds to himself without the necessity of making equivalent distributions to RJ. It is thus self-dealing for Mike to rely on a capital accounting that is unfairly favorable to him, allowing himself to return more capital to himself and to Janet than they're actually entitled to. Mike's position is that he has acted fairly and reasonably by utilizing a conservative approach to preparing that accounting. However, Mike does not seem to contest that the capital accounting is not consistent with the truth about the income and expenses of Erwin Farms 2 that was established through hard-fought litigation. A court had to decide what the income and expenses of this LLC were because there had been commingling of funds and the manager couldn't actually trace where funds had gone between 2013 and 2015. In fact, at trial, Mike testified he was willing to utilize the judicially determined facts. At page 172, lines 6 through 11 of the transcript, he was asked question, have you expressed a willingness to revise this capital accounting further if RJ says he would want to use the total income and expense amounts calculated by the court in attachment A? Answer, yes. To be sure the court understands the problem, I'll break it down. In the first lawsuit, it was shown that the funds of Erwin Farms 2 had been commingled with Mike and Janet's personal funds. There wasn't even a separate account at the beginning of the LLC. Mike has admitted that he's never prepared an accounting that actually traces what dollars went where. So in the first lawsuit, the court did determine that there was actually negative cash for this entity in those first 3 years. The expenses did outstrip the income. However, we don't know what money was used to pay what expense. And the mortgage debt at issue was not 100% of the expenses of the LLC. So to use a concrete example for the court, in 2013, the court found that the total mortgage debt was $97,099. That was 76% of the company's expenses. So had we applied that percentage to the net loss of the company, that would be $18,488.51. That may be a more fair allocation of the funds shortfall to Mike and Janet's capital accounts than the full $30,100.30 that they've claimed they're owed as a return of capital for making the mortgage payments. Mike's approach, which is admittedly not consistent with judicially established reality, unfairly credits Mike and Janet personally for capital contributions when debt was paid with Erwin Farms 2 funds. As a remedy, consistent with the court's equity jurisdiction and equitable powers, RJ requested that the court order Mike to work with the company's accountant to prepare an accurate capital accounting that will govern moving forward. This is consistent with section 4.1 and Section 11.12 of the operating agreement. I'll move on very briefly to the leases, starting with the issue of how acres were rented by Erwin Farms 2. The basic issue here is that it appears defendant utilized a lease and sublease structure to avoid the appearance of self-dealing. So instead of leasing acres to himself directly, he first leased them to a tenant and then leased the hay and pasture acres back to Janet, who runs the cattle operation with Mike. That's all admitted. Then the acres that were supposed to be utilized as pasture, RJ submitted a significant amount of evidence was actually used for hay. Hay rents at a much higher price than pasture acres. So Mike got the benefit of renting acres at a pasture price that he should have paid the hay price for. And this led to a significant shortfall of rent for the LLC. I see that my time has expired. Thank you.
Counsel, and you will have more time on rebuttal. All right, Counsel, are you ready to proceed? Yes, ma'am. All right, whenever you're ready.
May it please the court, counsel. As opposing counsel succinctly outlined, this is a family farm dispute that's been spanning almost a decade. Emotions have been high throughout that decade. There's been significant disagreements over the management and the operations of the farm. All of this arising from Mike and Janet Erwin's attempts to put into place estate planning and preservation of assets for their kids and grandkids. RJ, in this case, the third lawsuit in 4 years brought against Mike and the management of the farm, is really attempting to manage the farm through litigation rather than through the terms and conditions of the operating agreement. Specifically, we are not here to relitigate the prior lawsuit. We're not here to talk about prior bad acts and whether those prior bad acts mean that Mike is a bad farm manager and shouldn't be allowed to manage the farm. I think if you look at the evidence presented to the district court in this case, there is a lot of self-serving testimony. There is a lot of unsubstantiated testimony regarding damages, regarding operations, where RJ speaks to this is how things were done, but there's no testimony as to supporting that or any other issue of, you know what, let's get John Davidson, who was a tenant farmer, let's have him testify as to how this farm was actually being operated and actually how this lease was operated. That's not in the record. Let's talk to the individuals involved with the replacement of the fence and see, hey, these fence posts that we're complaining about that supposedly left the property, that we don't know how many actually left, but we're going to make some substantial guesses as to what that is and the value of that is, and say that Mike breached the operating agreement by allowing these to leave the property, but we're not going to call the guy who actually did the work as a witness. So I think if you look at all of this, you look at the history of this case and this family farm dispute, it's a lot of respectfully sour grapes over the management of the farm and how things have gone. I'd like to briefly address a couple of the issues raised by opposing counsel in a little bit of reverse order. The capital accounting, there is no dispute that Mike, in formulating the math and doing the capital accounting for the mortgage payments, used stipulated damages and stipulated profits in calculating that. The purpose behind that was to perform a conservative mathematical approach to this that is not reflected when you use percentages in accounting for cash on hand. Again, the records at this time, as established in the prior lawsuit, were murky. There was unknown amount of cash on hand. So by using stipulated expenses and stipulated income, Mike took the most amount of money that Erwin Farms could have had on hand in the form of profits, applied it to the stipulated expenses, and what remained of the guaranteed expenses in the form of mortgage payments is what we took as a credit, or what Mike took as a credit for capital accounting.
Shift and spend some of your time addressing the attorney fee claim I spent some time talking to your opponent about.
Yes.
Our easiest way to navigate through that would be.
I know I just got done saying this is not a relitigation of the prior lawsuit, but I think it's I think counsel hit it right on the head. The prior lawsuit awarded RJ attorney's fees under the exact same provision. To stand up and say that they were not afforded notice under the contract, that they had, that attorney fee shifting was a cost and expense, not a damages. It's a cost and expense under Iowa law when it's contractual in nature. That they didn't have fair notice of that fee shifting provision is hard to believe when they were awarded $5,000 in fees under the same provision in the prior lawsuit.
It's a little double-edged sword, right? Because you pled it the first time, why didn't you plead it this time?
Well, just because it was applied the first time and pled the first time does not mean that was required to be pled. And I think that's the distinction that Iowa case law makes. Mike would not have had any, Mike or Erwin Farms, and there's two different means of getting to this fee transition or these cost and expense shifting. You have it through contractual analysis, which is what we argued in our briefing, in which you say Mike and RJ are both parties to this operating agreement. They're both parties to the contract. These are read. In fact, all of the fiduciary duties alleged in this lawsuit were brought pursuant to the contract. You can't breach a fiduciary duty unless it's either contained in the operating agreement or in 489. In this case, the operating agreement serves as the governing document for those fiduciary duties, and it's expressed, and it says in here, the prevailing party in the litigation is entitled to recoup their costs and fees incurred through attorney's fees, and that is a cost shifting or a fee shifting provision that is not a damages provision. And that,
Authority that should fall into the contract bucket rather than a statutory bucket.
well, I think you go through our briefing, and you've got the Ailes case. And these are all, admittedly, the law in this area, specific area of applying operating agreements as contracts is sparse because generally that's not what's litigated over. It's generally presumed that contract principles govern this. But if you look at Ailes, you look at some of the other cases, and I apologize, I don't have them off the top of my head, that discuss fee shifting provisions, and I think the clearest one is the federal court applying Iowa law in a district court context saying, hey, we're gonna look at this, but this idea that 625 has to be pled is wrong. The trigger for fees and cost shifting isn't even available until you have a judgment entered in your favor. You have to establish that you were entitled to those costs. It cannot serve as an affirmative defense. It cannot serve as a damages claim at the beginning because you don't know what you've incurred. You're more or less speculating on facts that you can't plead, saying, hey, we're gonna be entitled to attorney's fees no matter how long this goes on, no matter what the outcome. We believe we're gonna be entitled to attorney's fees. And I just don't know how you can plead that. I mean, you can plead it. You can put them on notice, hey, by the way, in case you overlooked it, here's this provision in the operating agreement saying, hey, we're entitled to fee shifting based on the party who's victorious in this or the prevailing party. But to sit there and say, hey, you have to plead substantial facts, or you have to plead sufficient facts to prove or to show that you're going to be entitled to these when you don't have a judgment to point to yet, is problematic in a pleading context. Obviously, you can put them on notice, but I don't think there's any requirement that you have to.
District court have said in its discretion that it thought you did need to provide notice and deny fees on that basis here.
If it, no, and that gets back to the two routes that you can take to get there. The first is, even if we were gonna say, okay, this doesn't fall into the contractual bucket, let's take a look at another route. The contractual bucket 625.22 is mandatory fee shifting provision. Iowa case law is clear. Hey, you don't have to plead that, you just have to claim costs and expenses in your pleading to entitle you to this. The second route is the manager indemnity reimbursement route. It's under 489.408. That route is mandatory as well, not discretionary, in that the LLC is required to reimburse Mike if he is successful in defending his actions on behalf of the LLC. In this case, Mike was successful, was found not to have breached a fiduciary duty, was found to be the prevailing party. The LLC, in this case Erwin Farms 2, is required to reimburse if they haven't already forwarded the money to him for his expenses and costs in defending the LLC. And then, even if we were gonna take this out of the contract perspective, RJ still owes duties under the operating agreement to indemnify the LLC for its costs in defending against the in defending against the litigation. That's under section 11.14 of the terms of the operating agreement. You can also infer that under 4.13. There's an express,
And get you your full award of attorney's fees, or is there some portion that wouldn't be covered?
potentially if we were to take a case by, or a claim by claim evaluation of all of the claims, you'd have to link each of the claims to a fiduciary duty that was alleged to be violated. And I think if you look at this, and I think there's 9 claims, opposing counsel is correct, there's significant issues that they've raised on appeal, but the first 4 are derivative. There's 3 direct claims, all arising under the operating agreement. And then you look to the issues involving equitable and injunctive relief, and how much of that is actually attributable to attorney's fees. District court did not undertake that evaluation in this context. I don't know that you could necessarily link those, but I think an argument, it's a reasonable argument to be made that those injunctive and injunctive and equitable relief was sought under the operating agreement to replace the manager and install someone else. Again, something not allowed under the terms, but that's what was sought. And for those reasons, we think that the attorney fee itself is entirely recoverable and appropriate. And based on the lack of support in the record and the judgment of the district court in evaluating the testimony of the witnesses, we would ask that this court affirm and award appellate attorney's fees to Mike and Erwin Farms too.
Keeping question quick.
Yeah, you can go ahead.
Were you gonna file an attorney fee affidavit for those appellate fees?
Once we had established the cost of those and a judgment had been entered, that was the plan. The other option would be to request remand for a determination before the district court on what was expanded. The holdback on that was obviously wanting to make sure we had an appropriate amount and cost established before we filed that affidavit.
Not sure I heard an answer if you're gonna file an affidavit or not.
We will be, yes. We have not filed it yet, excuse me, but we will be filing one, yes.
All right, thank you, counsel. All right, and counsel, you do have 5 minutes for rebuttal at this time, whenever you're ready.
Yes, thank you. Because we're on this topic of the attorney fees, I'll circle back to that briefly. In the reply brief submitted by Appellant, we did address all of the cases that were cited by the defendant and appellee, and you will note that all of those are what you would expect. Those are straight up breach of contract type of cases. Estates at Woodland Hills considered a breach of a purchase agreement. Dutrack considered action for breach or foreclosure of a commercial lending contract. The Ailes case concerned a written covenant not to compete. I mean, these are breach of contract types of cases. There is no Iowa precedent establishing that a breach of fiduciary duty claim pursuant to Chapter 489 is an action on written contract where attorney fees don't have to be pleaded and they are considered sufficiently pleaded by asking for dismissal at plaintiff's cost.
Opponents claim that the indemnity argument gets into the same place.
Yeah, I think indemnity is a totally different subject, right? So indemnification of the manager by the LLC is not a direct damages award against RJ. Whether he can repay his attorney fees from the company's funds is another matter entirely. Now you can say, well, perhaps half of that money is ultimately owed to RJ anyway, but it's not money that RJ has now. So the LLC's funds being used to indemnify Michael Erwin and RJ owing a damages award to the defendant are 2 entirely different topics that also was not briefed or argued prior to now.
Is it your position that if he were going to get attorney's fees, it would have to be essentially as a direct action enforcing the rights of the operating agreement? Is that how attorney's fees you would enforce that provision in the operating agreement?
Yeah, so I think the pleading standard, even on statutory attorney fees in Iowa, is actually a bit murky. And that's noted in that Nelson case where it's not clear whether you have to bring a direct claim. I think it would have been sufficient if their prayer for relief said, and prays for an award of attorney fees pursuant to the operating agreement. We would clearly have been on notice at that point. That is not what occurred in this matter. I want to touch on something else briefly, this sort of insinuation that we're trying to manage by litigation. I think the facts clearly establish that after the conclusion of the first lawsuit, defendant slipped back into his bad habits. RJ had to demand accountings for 2019 and 2020 before they were provided. RJ had to demand and then file suit to receive accountings for 2021. The manager has never provided accountings as they are supposed to be provided under the operating agreement, which include typical things like a balance sheet, cash flow, statement of equity. There is a provision in the operating agreement that provides for the court to specifically enforce the operating agreement. RJ has asked for that to happen repeatedly in the hopes that we can avoid some of these disputes. He just wants the law and the operating agreement followed. And if the court had enforced the operating agreement that governs, that might be an effective remedy, and it's clearly provided for, and both parties did sign off on that. So the reason that he has continually had to go back to court is because defendant will not comply with the applicable rules. I'm going to go ahead and rely on our written briefing for all of the other topics, as I don't think there is sufficient time to get into them today. I'm happy to answer any other questions that this court may have, but otherwise I appreciate your time, and we would pray that this court grant the relief requested in our briefing. Thank you.
Thank you, counsel. And thank you both for your efforts in your briefing as well as your arguments here this afternoon. We will consider this matter submitted, and we will have a ruling out as soon as we are able.